With me now, I have trial attorney Neama Rahmani. Thank you so much for joining us today. And let's talk a little bit about the defense opening first, because I want to talk about the facts in this case, the facts and the law. The facts are, and they just said, you're going to hear evidence that, yes, she has injuries from the top of her head to her feet, and she fought. But that there was an absence of the defendant's DNA. What do you make of that as an opening argument for the defense in this case, Neama?
Judge Ashley, a day after almost being fired, Nate Rowland's public defender came out swinging. And really, this is all she can do in this case. I mean, really point to the lack of evidence, because there is so much overwhelming evidence that the state didn't need to prove that there's the victim's DNA under Nate Rowland's hands and that type of thing. But when you have a challenging case like this as a defense attorney, you have to go on the offense. You have to talk about a sloppy prosecution, lack of evidence, rush to judgment, and those types of things. And those were the central themes in her opening statement today.
And Neama, she has some really valid points. And if I were a jury member listening to this, I would think, well, I wonder why not? Why didn't she have any of the defendant's skin or DNA on her if she fought? So I think it's also laid the groundwork to get the attention of the jury to really listen to the forensic evidence in this case. Let's talk about something else that you said, and that is the evidence is overwhelming. And I believe in this case, a lot of that evidence is going to be the video evidence of her getting into the car, as well as two individuals, same clothing, same presumed individual being the defendant, at the ATM machine. What pieces of evidence stick out to you as something you think is really going to be important for the state to prove in this case?
Judge Ashley, from the beginning to the end, there's so much evidence against Rowland. There's the video surveillance of the victim getting into his car. There are social media pictures of him in front of his car, that Chevy Impala. It's his car. There is the video evidence of him using the victim's ATM card, trying to use it. There's her blood in the back seat, her blood in the trunk, her cell phone in the vehicle. And most importantly, when he is pulled over by law enforcement, he flees. I've been thinking about this case a lot, and I've thought to myself, what's the only possible defense in this case? And really, it would have to be that someone took my car and committed this heinous, gruesome murder. But, fleeing when law enforcement and taking off, that's something that really undermines and undercuts that argument.
Well, so it's interesting you say that, because it's my understanding that the defendant's father, Henry Rowland, in fact, did tell a Fox affiliate that his son was at a party at the time of the abduction, and that he passed out. When he finally woke up, he went to search for his keys. They weren't in his pocket, found his car, opened the door, the keys were there, there was blood everywhere. Now, we don't know whether or not that is going to be his defense, but we do know that's what the father claims. What are your thoughts around that version?
Well, it's really the only possible defense that you can present in this case. And Rowland's family has been very active in the media defending their son, both brother, mother, and father. So this is not unexpected. But again, it's a very implausible story. The jury would need to assume that, you walk into your vehicle, you see blood everywhere, and you don't do anything, you continue driving. And when law enforcement pulls you over, instead of telling them immediately what happened, you take off and you run. So certainly possible, not a particularly reasonable story. I really like the prosecution's case here.
And let's talk a little bit about the law in South Carolina, because quite frankly, I have the advantage of looking at the statute. It's fairly straightforward in terms of the definitions of the things that this defendant's been charged with. So the first thing, Neama, that I'd like to start with is the charge of murder for murdering this 21-year-old college student. And it says specifically in the state of South Carolina, murder is the killing of any person with malice aforethought, either expressed or implied. It's a pretty simple definition, so I think if there's evidence beyond a reasonable doubt that shows he did this with malice, that he's guilty of murder.
And I think, Judge Ashley, I think the 30 stab wounds or more, that's where we get that malice.
Yep, I agree. Let's go back in. It looks like they're resuming seats. Let's watch. And now joining us for the first time on Court TV, criminal defense attorney Deborah Barbier. Thank you both for staying with us, for talking with us. I have to tell you, I have a wonderful producer who was doing a great let's go to this, and instead we're going to go straight back to the courtroom. I want to watch something with you because from my perspective, this is a little unusual. After the court dismissed for the day, the jury left the room. Then we saw the defendant had an opportunity to speak to his father. It's my understanding, and you'll see in just a minute, the gentleman in the dark blue shirt with the long sleeves, I believe, right there, is his father. And so, of course, I think appropriately, probably, it looks like security may have made certain that it was safe. And there they are talking. And let me just ask you, if I could, Deborah, first, I know that you're in South Carolina. This is unusual from my perspective. What are your thoughts about this, if anything?
This is highly unusual. I have rarely ever seen the court security officers allow a defendant to visit with the family members during a break or after a court session has closed. So I'm not sure exactly what's going on here, but clearly that's what's happening. But it is highly unusual. Generally speaking, they're not allowed to have communications, particularly when they're detained, and he's been detained since his bond.
Right. I know
hearing.
when I'm on the bench for juvenile matters that, you know, I'm a judge who will allow, for instance, if a young lady's been picked up as a victim of sex trafficking and the parents are there and hadn't seen her, I am one who will say to the deputies, out of restraints, they get to touch each other, and the deputies fight me and say, no, they don't, because of safety concerns, right? We're here to protect everybody, and I cannot have the mother, for instance, and a juvenile who may be detained having contact. And so that's why, from my perspective, the safety aspect of what you just laid out. Neama, do you have any thoughts? And the other thing I wonder is, of course, we all wonder, what are they saying? We don't know that. But Neama, any thoughts around as you watch this contact?
Judge Ashley, I agree with Deborah. This is highly unusual in any state or federal court where you have an inmate who's been accused of murder, who's been detained without bond, communicating with lay persons, even family members in the courtroom. This is highly out of the ordinary. And frankly, I've never seen anything like this happen in my 20 years of handling these types of cases.
I know. I love our producer and Court TV team because they noticed this and said, wow, this doesn't seem like something we typically see. Now, I did want to point out what else they just shared with me in my ear, and that is the defendant is, and you can see there, shackled at the waist, and you can see the chain behind him. And the father, I wondered why it looks like he's being held on each side. He apparently uses a wheelchair and is being held up there so that he can be standing across from his son. So the other thought I had was perhaps counsel needed to speak with the father, who may or may not be a witness or involved in the case in other capacities, and the son. But it looks like all of the defense counsel that we've met at this point in time anyways are, as you can see on your screen, putting their things together and getting organized, I'm sure, for their day tomorrow. So it doesn't even look like that's the reason. Just an interesting development. I will say this, I must add, this judge to me so far has not had to say much, but he to me is no nonsense. And here's why I suggest this, because he made very clear, for instance, I don't have the exhibits. And so when there's an objection, I have to wait for someone to give me the exhibit to even look at to make a ruling. And how are we going to rectify that? So being no nonsense, obviously I can't imagine this didn't get some type of consent or permission from the court. Having said that, that's what happened, and then you see the defendant being escorted out. All right, let's turn our attention now to some other things that I want to talk about. Deborah, I know that, again, you're practicing in South Carolina, a former federal prosecutor. Let me ask you this. Talk to us a little bit about jury selection in South Carolina, because I know that it started yesterday. We anticipated it might roll or be done by this morning, and it actually finished around lunch, and then we started with the trial at 2:30 today. Is that typical, or what happens with the jury process so they can select a jury before beginning the trial?
Well, jury selection in state and federal court here are very different. But in state court, it's a pretty tedious process, as it well should be. You know, you're looking for 12 people who are can be objective, and can be objective in this case a very highly emotional and a case that garnered a lot of attention in the media. It's an opportunity for the lawyers to ask potential jurors questions about whether they have biases in this case, whether they can be fair, whether they have heard anything about the case in the media. And this is a case that rocked this community, rocked the university community, and really garnered national attention and changed the way we regulate and govern rideshare apps. So it's received a lot of attention. That makes jury selection a harder process. I'm pleased they got it done today. I thought it might go on a little bit longer. So yes, it's very common for it to take a long time to do, and it's also a difficult in coming out of a pandemic, because we've got people who still don't want to be, who are called for jury service but don't want to be in rooms with lots of people and are not vaccinated and don't feel comfortable. So there's a lot of factors other than the publicity playing into this as well.
Yeah, excellent points. Thank you, Deborah. I know I've heard from Chanley Painter, who is there in South Carolina in the courtroom, who pointed out that 10 of the jurors are in the jury box, distanced, and then there are 4 others that are seated, I believe, in front, but close by, again, because of the pandemic, to your point. Now, I never write down when the actual first witness takes the stand. For some reason today I did. I don't know why, but I wrote down 3:13 p.m. Eastern time. My point being, Neama, we have heard from 5 witnesses between 3:13 and approximately 4:30 in a case that obviously involves a murder charge, a kidnapping charge, an assault with a weapon charge. That seems like those witnesses didn't testify for long. What are your thoughts?
I had 2 takeaways from this afternoon's testimony, Judge Ashley. The first is, how did the prosecution start their case? And that really gives you an insight into the witnesses that they think are important. You always want to start strong if you're the state or the government. And they started with Samantha's boyfriend, and he provided some good testimony about her and what he did when she was missing. But importantly, he also described the type of person that she is, because ultimately she's the victim and you want the jurors to identify with the victim and her family. Secondly, and Judge Ashley, you hit it, there was little to no cross-examination, absolutely none for 4 of the 5 witnesses. Very brief cross-examination of the real Uber driver who was supposed to pick Sammy up. So I know there's client control issues with this particular defendant. He tried to fire his defense team the day before trial, yesterday on Monday, and you have to really wonder what he's thinking here, because one of the concerns that he had is, my attorneys aren't fighting for me. And the fact that we've seen almost no cross-examination here has to be concerning for the relationship between defense counsel and client.
But I will say this, if you look at his mugshot when he was arrested and how he looks in court, the defense has done a good job preparing him for court. I think he looks very different. He's dressed very nicely, his haircut, clean shaven. I think they've done that well to present him to a jury that begged the court's indulgence. I'm glad to know exactly what they were saying, and just an interesting point about how different trials can be in different locations. Neama, I feel like in this case, they really have done a good job, the state. I agree with Deborah, laying out a case chronologically. I feel like, as I listen to the presentation of evidence, that it's as if law enforcement would be following the evidence in each step that they've discovered and learned, walking me through exactly what happened.
Judge Ashley, those polite Southerners there in South Carolina, if only they got their exhibit binders ready for the judge beforehand. But I agree with you. I like the presentation, how it started in terms of who first notices Sammy missing and the steps that they take and law enforcement coming in. And the reason I like it is because not only is it a strong case, but it's a very emotional one. It's gotten a lot of press, not just there in South Carolina, nationwide. And it's raised issues about rideshare services and the safety of Uber that Deborah's touched upon. So the fact that they've done a good job getting through so many witnesses in a very emotional case in a way that logically makes sense, both